Hi, and welcome to today's edition of the Kessler Law Firm podcast. I'm your host, Michael Kessler, and we may talk about the law some days. We may talk about other things. Today, we're going to talk a little bit about prosecutors. So the other day, I found myself at one of my favorite watering holes, holding court and swapping war stories with a couple of younger criminal defense lawyers. The subject rolled around to the recent spate of wins by the defense bar in Fort Pierce. One of the young defense lawyers said, "Man, if I were a prosecutor, I would never lose at trial." The other young buck said, "Why?" And he said, "Because I would only go to trial when I had an open and shut case. If the cases wobbled, I would settle them, and I'd win 100% of my cases." I nodded, waited for them to finish, and then I said to the young buck, "No, you wouldn't." "What do you mean?" "Well," I said, "you would have to deal from time to time with the bad guy rule." "Bad guy rule? What's that?" "It's a political rule passed down by the top of the food chain down to the younger lawyers at the prosecutor's office who aren't in a position to make policy. They're just in a position to carry out policy. The bad guy rule is an exception to the sense that this young defense lawyer had about what cases to try. I mean, the caseloads are just too big for prosecutors to try every single case. There's no time, there's not enough work hours, there's not enough courtrooms, not enough judges, not enough prosecutors for any prosecutor to take to trial every single case he or she has. So they have to make choices based on priorities. And the priorities should begin and end with, how strong is my case? How much work is it going to be for me to put this case together and present it in front of a jury? And taking into account the law, the evidence, and the defense attorney's perceived skill set, what are the chances I would do all that work and not win? In other words, if there were two virtually identical cases on the docket for trial, and the prosecutor only had time to try one of the two, one would expect the prosecutor to take into account the law and the evidence, but being these are identical cases, the perceived skill set of the defense attorney. And the prosecutor would be expected to pick the case with what he or she perceived as the weaker skill set of the two defense attorneys and take that case to trial and do whatever it takes to settle the other case. But here's where prosecutors, even experienced prosecutors, run up against the bad guy rule. The bad guy rule forces the prosecutor to take into account matters that are completely irrelevant to their chance of winning and losing. And that is, do you think because of a particular defendant's prior unrelated criminal history that he's a bad guy and you should just do whatever it takes to try to beat him at trial, even if it means losing? I think this is a silly rule. I think it'd be a much better idea to settle the case, even if it means probation for somebody who might deserve jail or prison time. Settle the case, get them on supervision, and if they're really a bad guy, catch them breaking the rules of probation supervision and deal with them that way. I'll give you a couple of examples. Let me tell you about a client of mine we'll call David. David is what I call a frequent flyer. That is somebody I have defended many, many times over the years. About 25 years ago, I got a not guilty verdict for David on a tough case that the prosecutor probably should have won. And I remember the prosecutor, but I don't remember the specific details. Some 25 odd years later, David comes back to me with Still another problem. David, you see, was a married man by this time with a couple of children. And despite occasionally, frequently, regularly running afoul of the law, he was also a fairly successful local business person. Well, David and his wife were having some marital difficulties, and David strayed. Not for very long. Eventually, he decided he was better off where he was, and his wife was a forgiving woman, and they patched things up, and life went on. About 2 years later, he gets served with child support papers. He didn't know he had a son. Turns out that he had a 2-year-old child with the young lady with whom he had his dalliance. And David, being a multiple time convicted criminal, did exactly what you would expect him to do. He told his wife about it, and the two of them went to see the young lady. And what they said to the young lady was, well, what David said to the young lady was, I will take full responsibility. I'm a good dad. He said, in fact, my wife and I will take custody of the child because we can provide for him better than you can with your other children. The baby mama laughed in his face, called him a couple of names, and told them to leave. David, being a multiple time convicted criminal, then went out and did exactly what you would expect him to do. He hired a lawyer to file suit for custody of the child, and he waited for his day in court. One morning, before their court date came around, baby mama called the police. Baby mama claimed that David had encountered her, argued with her about the child, and when she wouldn't give in to what he wanted, he punched her right in the mouth. She went into a neighbor's house and called the police. Nobody saw this happen. When the police came and interviewed her, they observed no marks of injury. She claimed he punched her right in the mouth. One might have expected her to have a cut lip or a fat lip. She didn't. No bruises, no blood, no nothing. They went over to David's house. They found him out in his yard. He said, I don't know what you're talking about. And they chose to charge him anyway. And the case rolled around to trial. Now, the prosecutor had no corroborating evidence, no physical evidence, no witness. A he said, she said case where obviously the accuser was motivated to lie. If she could get David convicted and get him in jail, then he would have to lose the custody case. The first time we tried this case, it ended up being the fastest trial I've ever had. I tried to reason with the prosecutor that her case had no jury appeal. I didn't argue that my client was innocent. I merely argued that the state wasn't going to win this one. They had bad facts, bad evidence. And the answer I got was bad guy rule. David's a bad guy. I'm not offering anything. David has to go to jail. David's a bad guy. I said, all right, well, let's pick a jury. So we picked a jury. I gave the fastest opening statement I've ever given. I looked at the jury and I said, pointing to David, this is an innocent man who's been wrongly accused. Let's get to work. And I turned around and sat down. Prosecutor began her case by calling the accuser and did a not terribly compelling direct examination, but got the witness to say what she needed to say, that David had punched her in the mouth. I got up and I walked over and I put my arm on the jury box and I looked at the witness and I said, let's start by talking about the things you and I agree about. She said, okay, because she didn't have any choice. And I said, we can agree that you are a convicted felon. She immediately pointed at David and said, so's he, at which point the judge did a face palm sent the jury out, listened to a very brief argument, and declared a mistrial. For those of you who don't know, it's perfectly okay to tell the jury that a witness has a prior criminal history of a certain kind. Convictions of felonies, convictions of crimes involving false statement, dishonesty, those kinds of things are fair game. But neither the defendant nor anybody else can be blamed for having a felony conviction if they don't become a witness. So obviously this was an improper statement by the prosecution witness that could have tainted the jury. And so the jury was sent home. We picked another jury on a different day. So just to remind you, the bad facts: prosecutor had no corroborating witness, no corroborating physical evidence, no photographs, no injury, no fat lip, no cut lip, no blood, no bruise. And on top of that, the witness was a convicted felon and had a motive to lie. And yet, when it came back up for another trial, we went to trial again. The result was, as you probably would expect, the jury stayed out only long enough to go to the bathroom and pick a foreperson, and they came back after about 15 minutes, not guilty. This is a case where, because of our concerns about David's history, he might have made a deal. He might have taken a plea to probation just to avoid the risks inherent in trial, because any trial lawyer will tell you one never knows what a jury might do. An even better example of the bad guy rule that guides prosecutors is Mark. Mark had a significantly worse record than David. Mark was a multiple-time graduate of the Florida Department of Corrections, also known as the state prison system. Mark had a sort of a cousin who also was a graduate of the Florida state prison system. Mark was several inches taller than his cousin, but the cousin had a build like Marvin Hagley, like a middleweight boxer. I mean, he looked like he was carved out of a fire hydrant or a piece of stone. Anyway, Mark and cousin were not getting along these days. Some say it was because of a woman. But these two gentlemen found themselves half a block apart at two separate bus stops on a school day afternoon, both waiting to pick up children that were not theirs to take them home. I say that perfectly legally. They were they were innocently each going to bring a child home. But from half a block away, they're talking trash to each other. At one point, Mark turns toward a guy next to him, hands him his hat and his cell phone, and kicks off his flip-flops. That was a recognized signal to his cousin, I'm ready to fight right now. The cousin, recognizing that signal, reached into his pocket, took out a trenching tool, and opened it to the knife blade, saying without words, I'm ready to fight right now too, but I'm fighting with this. The two men came together. Mark either didn't notice, didn't care, didn't understand the value of the knife, and Mark attacked and got stabbed in the belly for his trouble. Others there broke them up. The shorter, stronger, younger cousin took his trenching tool, got on his bicycle, and rode home. Mark, holding his belly to try to staunch the blood, started walking home. Some kind soul saw Mark walking, offered him a ride, picked him up. Moments later, the driver, recognizing that Mark was bleeding all over the interior of the car, took him to the hospital. While Mark was at the hospital, the police came calling. The police interviewed Mark, who, despite his many trips to criminal court, answered every question the police had, told him about the fight, told him he got stabbed, told him who stabbed him. The police went over to Cousin's house, and Cousin told him everything too, admitted doing the stabbing, told him the whole thing. And the police made a decision that they should charge Mark and not the guy who stabbed him. They charged Mark because they decided Mark is the one who started the fight. Even though Mark was using his hands and the cousin was using a knife, they decided that the cousin was standing his ground and just defending himself. So they charged Mark with a misdemeanor battery. Now in Florida, a misdemeanor battery can be bumped up to a felony battery if the defendant has a prior battery conviction. No matter how long ago, no matter what kind of a prior battery, could be a bar fight, could be domestic violence, doesn't matter. So the prosecutor's office bumped this case against Mark up to a felony. I met with the prosecutor the week before, and she said, I know you're going to beat me in this case. And I said, well, why don't we settle it? Why don't we plead him to, there's a crime called a fray. And I said, after all, these are two grown men fighting out on the street in broad daylight. She said, no, I can't do it. Bad guy rule. Okay. We went to trial the next week. I get to the courtroom the morning that we're going to start evidence, and my client and his cousin are sitting next to each other in the audience. And when court begins, they exchanged hugs and they went to where they were both supposed to sit. I get up to give my opening statement a little while later, and I look at my client and I look at the cousin sitting in the back of the courtroom. I look back at the jury and I say, you all might wonder why you're here when you hear more about this case. This case doesn't belong in criminal court. This is two grown men fighting each other in broad daylight. And I looked back in the back of the courtroom and I repeated that this case doesn't belong in criminal court. And the cousin is shaking his head in agreement with me. When the prosecutor put the cousin on the witness stand and asked him questions about the fight, he got angry at her and said, why are you bothering me? I've got problems. He's got problems. We're working them out. We don't belong here. I don't think that jury waited long enough to even go to the bathroom. If memory serves, they were back in 5 minutes with a not guilty verdict. In both of these cases, yeah, I was prepared and I did a good job presenting my case, but neither one of these cases should have gone to trial. Both of these defendants would have been willing to compromise to avoid the risk, but the prosecutors relied on the bad guy rule and lost both trials. Now, I've never been in charge of an office full of prosecutors. It's not something I aspire to, but if somebody forced me to do it, yeah, the bad guy rule would go out the window right away. Thanks for joining us today on the Kessler Law Firm podcast. Whether you're watching this on YouTube or listening to it on your favorite podcasting site, please click subscribe or follow. So next time you come back, our latest podcasts will be ready and waiting for you. If you'd like to connect and find out more about us, visit our website at www.kesslerlawfirm.com. Thanks and have a great day.